a dead end. The bill was the focus of discussions at a recent meeting of the National Integration Council chaired by the Prime Minister, attended by Chief Ministers of 21 states. While the Congress and its allies largely supported the bill, the BJP strongly opposed it, calling it dangerous. One of the biggest allies of the Congress, the Trinamool Congress, also opposed the bill in its present form. The objections to the bill are primarily on two counts. The first is that the bill violates the federal structure of the constitution, and the second being it is likely to fuel distrust between majority and minority religious communities. Whether it's the Delhi riots of 1984 or Gujarat riots of 2002, the fact remains that the quest for justice seems to be never ending. The government has asked the National Advisory Council to draft the Prevention of Communal and Targeted Violence Bill to combat the recurrent problem of communal hatred and riots erupting in the country. Today in Public Forum, we discuss the need for such legislation in our country and whether it can make the situation better for troubled groups in the country. The same, we are joined by three distinguished guests in our studios. Please welcome Mr. H.S. Phoolka, a senior advocate. Sitting next to him is Professor Rakesh Sinha, an honorary director with the India Policy Foundation. And we are also joined by M.R. Madhavan, a head of research with PRS Legislative Research. I welcome you all to Public Forum. We'll begin the discussion with Mr. H.S. Phoolka. Mr. Phoolka, before we talk about the merits and demerits of this proposed legislation, let's begin with the need for having such a legislation in the first place. Why do you think we need such a piece of legislation?
Because the reason is that these three large-scale violence which has been experienced in the country in 1984, then in Mumbai, and after that in Gujarat. And it has been seen that in all these three, I mean, by and large, this was with the patronage of the party in power. And by and large, the people who against whom their allegations came, they were rewarded. They may be bureaucrats, they may be police officers, or they may be politicians. All of them got the rewards after that. And by and large, the criminal cases against the perpetrators, they were suppressed.
Okay.
They were not properly registered. And it was seen that wherever there was a discretion vested in the police officers, when their duty was to control the violence, but instead of controlling the violence, they were listening to their political masters.
Okay.
And were not performing their duties properly. So this was noticed. Then other aspect of this bill is a compensation to the victims. It was noticed that the compensation to the victims was not given properly, and the victims had to run from pillar to post. In case of 1984, the compensation was given in 1996 after 12 years, which has lost the importance of the compensation. So these are the things which, due to which this bill is necessary, because this kind of a violence, they hit the basic secular structure of the constitution.
All right.
So therefore, it is necessary to bring about a bill. Many people say the existing laws are necessary. Existing laws, though are necessary. What in their implementation, when the discretion is vested in the officer, that discretion is misused.
Okay.
Not to perform their duties properly. So therefore, the law has to be made in such a way that they are under a threat. The officer should know it, that if he derelicts from the duty and if he does the illegal things, he will not be rewarded, but he will be punished.
Okay.
And that the discretion is not left to the moment the large scale violence occurs. There should not be any discretion. The officer has to act in a particular fashion, call the army, control the violence. I mean, like one step, 1, 2, 3, 4 should fall like this. I mean, that is the purpose of the violence, of the bill.
Okay.
And these are the, unfortunately, this has been 6 years that this has been pending. In 2005, last bill was introduced. And in 2007, I gave my presentation to the Parliamentary Committee of Home Affairs. I made many suggestions. And after that, in one of the meetings, the chairperson was Sushma Swaraj. In one of the meetings, she met me after that. She said, we have accepted most of the suggestions given by you. And unfortunately, after that, again, the bill was reconsidered. It went to NAC. Now this bill has come. It is again in controversies.
So you're saying the need for a special bill or a separate bill to look after the the communities, minority communities, scheduled castes and scheduled tribes and right victims is basically to give them justice.
Let a message be given by the country that that is a zero tolerance to any of the communal or caste violence.
And you're saying the problem lies in the discretionary powers given to our officers.
And any citizen, he has a right to live honorably in this country. If there's even if there's one person and the other side there are thousands.
All right, but I'll come to you, Professor Rakesh Sinha. Then what is the problem with our existing laws? Why is it that despite having adequate laws in place, we haven't been able to give them justice, the right victims?
First of all, I will agree with Mr. Phoolka that there should be zero tolerance to communal violence or caste violence. There is no two opinion that communalism and caste violence should be prevented at any cost. But my point of view is here is that this bill has been introduced, has been framed. The makers of the bill made the worse than the disease. Three things I have been raising in this bill. They have divided the citizenry in two parts. Okay. One is group. Group consists of the scheduled caste, scheduled tribe, and minorities and linguistic minorities. Here I will point out why the scheduled caste and scheduled tribes and linguistic minorities have been taken into the group. SC, ST have their own laws. There is a National Commission for Scheduled Castes and Scheduled Tribes. There is a harder laws for them, and I think they are functioning well. If there is any lacuna, there are intellectuals, scheduled caste, scheduled tribe NGOs and groups, they are acting. I think they have been taken only to disguise the real hidden agenda. Hidden agenda is the law is privileging the minorities. The law is based on the future law will be based on the exclusion. It is excluding Hindus.
Okay.
This law is basically against the majority community.
Okay.
What they have been pointing out, just I am giving one example. They say the coercive environment against the group or members of the group. What is the coercive environment? If any shopkeeper complains that some of the customers create problems because of his religion, now they have to prove that they are not creating the problem. If a landlord, suppose I am a landlord, you belong to a group, and I say you that kindly now vacate my house. You say, you make a complaint that being a minority community, being the part of the group, I am being victimized, then I will be under this law, this draconian law. Means what I am saying that this proposed bill has given enough opportunities to create a hatred between the majority and the minority, number one.
Okay.
It is also based on the assumption that there is a permanent majority, there is a permanent minority. I will remind the makers of the bill, who are the campaigners, who are the crusaders, who are not the authority on the communalism or secularism. In the Constituent Assembly, Tajamul Hussain, a member of the so-called minority community, said the term and the concept of the minority is the British creation. They have gone with them the concept and term of the minority.
But here also, Professor Sinha, the minority, it changes from state to state if you go through it carefully.
In Jammu Kashmir, this bill is not applicable where Hindus are minority. And can you send the Kashmiri Pandits to Kashmir? You could not send Kashmiri Pandits who are living as a wretched life in their own country, number one. Number two, the bill is applicable in Nagaland, what you are talking of the Hindu minority, in some of the northeastern states. This bill is basically dividing the group, means the Muslim, for all practical purposes, this bill is for the Muslims and Christians. And the, others are Hindus. Second one thing, I am just talking about the sexual violence. This is the first bill in the world which is interpreting the sexual violence in communal context. Suppose two girls, college girls, are being sexually assaulted by criminals. Now one girl belongs to so-called group, according to this bill, other is a Hindu. Now the police will act more fastly, more actively, more sensitively for the girl who belongs to the group. And the girl who belongs to the Hindu community, she will not be taken care of so sensitively, so hurriedly.
What makes you say that?
Because the bill says, the proposed bill says, if any delay, any relation of duty while dealing with the sexual assault, the police officer or the bureaucrat will be punished. Second thing, this bill also interprets the mass rape. More than one woman belonging to the group, if raped, is a mass rape. So this is different. If 4 women of Hindu community is raped, that is not the mass rape.
Okay, so you're saying that minority communities and scheduled castes and scheduled tribes do not need any special law for protection.
This part of my statement. Here it is not important what is in the bill, because it is everything now in public domain. You go through the bill and you will find that bill is disastrous, its impact will be disastrous. Why this bill has been made? What is the motive behind this bill? What is the hidden agenda behind the bill? That these are become more important to expose the makers of the bill. They want to destroy the basic concept of the Indian constitution, the basic concept of the Indian civilization, which is inclusive. This bill is based on exclusion, philosophy of exclusion.
But don't you think, Professor Sinha, that communal violence attacks the secular and pluralistic nature of
Yes,
our
I
country?
agree. What I believe, communalism is a communalism. You don't make a difference between what he rightly pointed out. In 1984, the innocent people were killed, assassinated. The police officers were rewarded, politicians were rewarded, and the victims have not been paid compensation. My point is that you make a law which does not make a discrimination between the victims of the Hindu community and victims of the minority community.
Mr. Madhavan, what in your view are the salient features that set apart this draft bill from the existing laws in our country that we have in place?
See, what does this bill do, finally? It actually defines something called communal violence, which we don't usually do. I mean, it's usually part of the normal criminal justice system of the IPC and various other acts. It provides for a special process of prosecution and of offences and penalties. And most importantly, this actually sets up, as Mr. Phoolka said, a process for compensating the victims in law. So that is actually something new, which I would say is a fairly good part of the bill, which was there in the 2005 bill, also in a slightly different form, but the concept was there, that victims need to be compensated, need to get reparations, etc., etc. So that's the major part. Now, of course, the bill has a lot of problems, even in a constitutional point of view. Firstly, I mean, many people have talked about the group and whether differentiating on the basis of a group violates Article 14, right to equality. Another Article 22, which says that no person can be prosecuted twice for the same offence. There's a particular section which says that if there's an offence under the SC/ST Atrocities Act, this will not preclude prosecution under that also.
Okay.
So that would, I would say, that double jeopardy is being violated. There's a federal structure being violated clearly, because National Commission is going to talk about law and order, which is actually a state subject. There are several others, we can talk about that. So several issues through the bill which actually weaken the bill. But the intent is clearly to make sure that if there is communal violence, firstly to prevent such incidents, and secondly, even if it happens, you have quick prosecution as well as you have quick rehabilitation and compensation
and compensation for the victims of communal violence. On that note, it's time for us to take a quick break in the program. When we come back, the discussion will continue on the pros and cons of the NAC draft of the communal violence bill. Stay tuned to Public Forum. We'll be right back.